Good morning. Welcome to the Appeals Court. I am Justice Meade. With me today are Justice Hodgens and Allen. Will be the panel for all of your cases. Many of you have been here before. If not, each side gets 15 minutes. You needn't use all of your time. We don't entertain rebuttal. We have read everything. My best advice is to get right to the point. With that, I will call our first case, 25P 786, Commonwealth versus Muda.
Please the court, Adriana Contertesi for the defendant, appellant Arthur Mudd. On appeal, Mr. Mudd presents three issues. The first issue was, and I think probably the strongest issue, is that he was prejudiced by the admission of backdoor first complaint evidence. The testimonies of the sane nurse, the friend Hida, the friend Mrs. Calderon, and the friend Arnie all served no independent purpose, except to bolster the victim's credibility about what went on. For example, the sane nurse, well, the Commonwealth contends that, well, the sane nurse was needed because she testified to the collection of evidence. But the victim herself testified that she went to the hospital and had the evidence collected. And then Hilda, the Commonwealth contends that, well, her testimony and Arne's testimony served the separate purpose of identifying the defendant. But the victim had already showed that she had identified the defendant by working with the police, showing his Instagram pictures and his Instagram handle. And then Arnie, the Commonwealth also contends that, well, his testimony was probative of a joint venture, but it wasn't probative of a joint venture because actually the joint venture had nothing to do with any of those conversations. And what it boils down to is the fact that others made accusations of rape at the time of the party. It really did serve no purpose, and it wasn't probative as to whether or not the defendant committed the crime that he was charged of.
Yes, but doesn't Commonwealth v. King, a case on first complaint, actually expressly state that evidence otherwise independently admissible can come in, even if it might overlap first complaint evidence or not meet the standards of first complaint evidence, that it should come in anyway? So, for example, a number of these witnesses were recipient witnesses not to the rape itself, but certainly the aftermath within seconds of the rape. So why wouldn't their testimony be admissible?
Yes, they were recipient witnesses, but if you do the analysis pursuant to, well, what was the independent purpose as opposed to what was the prejudice that accrued to the defendant, it has to come out in the calculation that it was materially prejudicial to the defendant because none of these testimonies were really probative as to...
Did they testify that the victim told them that she was raped, or did they testify as to what they observed at the after party?
They did testify to what they observed.
Yeah, so they didn't, that's not fresh complaint testimony.
Well, this is... The defendant felt very strongly that this was impermissible backdoor first complaint evidence, and that the court should find that his trial was unfair because of it and give him an opportunity to have a new trial. Other issues that the defendant thought were very important was that, well, even though counsel did do a cross-examination on transfer DNA evidence, the fact of the matter is that he contends that expert testimony of his own testifying to the transfer of DNA evidence from his own bed into items that the Commonwealth tested would have made a material difference for him.
The problem you have is that you didn't file a motion for new trial. And this claim does not appear indisputably on the record. We don't have an affidavit from what this expert, what he or she would say. We don't have anything from defense counsel, and more importantly, we don't have anything from the trial judge as to findings of what effect any of this would have had. And on top of that, that was the defense that was argued fulsomely at trial that this was transfer.
Yes, it was fulsomely argued, and that is why the defendant decided to go for it on Commonwealth versus Zinsser, where it really is on the record. If there had been his own expert presenting that same evidence to the jury, it would have made a material difference in the case. I mean, it was his own bed. Of course, there was going to be a lot of his own DNA in it.
Did it really matter anyway? I mean, the theory that this was presented to the jury would have allowed the jury to return a verdict based on joint venture.
Then he was acquitted
so-
of, yes, of his own actions. But
Well, that's what, would it make any difference?
But nonetheless, these are the things that cast a defendant in a bad light, allow the jury to think that, well, you know, more than likely he probably could have done what the Commonwealth said that he did. And then the final issue, which the defendant also contends is very, very important, is that misstatements of the evidence by the Commonwealth in its closing argument also materially prejudiced him. There's 4 points the defendant makes. The first one is that it was not the defendant's idea to buy the Casamigos tequila. The defendant contends that it was very clear that it was the girls who wanted to have the Casamigos tequila. The Casamigos tequila was stronger, and that it was entirely their choice. The next one is that in the close...
Wait. What? They texted back and forth with Arnie, and Arnie told him, if you want to hit these girls, we better buy the tequila because it's stronger.
Yes, that's true. That's true. There was evidence that showed that, but the bottom line is that it was the girls that decided that they wanted the Casamigos tequila.
That wasn't objected to, right?
No, that was not objected to. The next misstatement was that the condoms that were found in the trash should not have been attributed to the rape. Especially because an earring that was also found in the trash was not the victim's earring, and even the police said, well, when we found that
The
earring...
condom wasn't hers either. The condom wasn't hers either. She testified that he put the condom on.
Yes.
And then there was a condom in the trash? You don't think that's a fair inference?
Well, no, especially because the earring that was found in the trash with the condom was not the victim's earring.
The first time, second time now, an argument, I still fail to understand the logic of that.
Well, the point is, it goes to unfairness. The condom argument, the condom was never tested. There were no fingerprints found on the condom packet. So the idea of attributing a condom in the trash to this particular rape, when the earring that was also found in the trash was not the victim's, and the victim specifically said, that's not my earring, was really not a fair inference, and that prejudiced the defendant. And the final issue is that the argument was that the argument in closing argument was that the defendant removed the victim's underwear, and that was objected to, so that gets a more favorable...
The victim testified that he removed her underwear.
The victim did testify that he removed her underwear, but
So how is that a misstatement of evidence?
But there was no... Pardon me?
How is that a misstatement of evidence?
Because there was no... because the underwear, after the police thoroughly combed the apartment, there was no underwear ever found.
Yeah.
So the defendant felt very strongly that that was an unfair statement.
What prosecutors do is they ask the jury to draw inferences in favor of guilt.
Yes, they do, yes.
And here there's evidence from the victim herself that he removed my underwear, volume 4, page 34, and the prosecutor gets to use that to establish guilt.
Yes? Yes, well, yes, but also, too, these inferences have to be fair, and a defendant is entitled to a fair trial. And the defendant feels very strongly that these different missteps rendered his trial unfair, and that he is entitled to a new fair trial. And I don't have anything else, so I'm happy to rest on the arguments presented unless the court has something else for me.
Seeing no questions, thank you.
Okay, thank you.
Ms. Garrell, am I close? Skrull, okay. At least I got it one syllable anyway.
Yes, just the one. Good morning, Your Honors. May it please the Court, Mallory Skrull, ADA of Middlesex, on behalf of the Commonwealth. I'll take the arguments in the order that my sister presented them. So to begin, the trial judge properly admitted first complaint evidence through just one Commonwealth witness, and the Commonwealth's additional witnesses provided relevant, independently admissible testimony and evidence which did not constitute backdoor first complaint evidence. First, Ms. Barrera, the first complaint witness, was the admission of her testimony was thoroughly considered by the trial judge before it was admitted to the jury. She was subject to voir dire and multiple motions in limine by both the defense and the Commonwealth before that testimony was admitted. Volume 1 of the transcript, pages 4 to 25, are her voir dire testimony, if the court wishes to review it. Her testimony was properly limited to the victim's statements to her that evening, as well as the victim's demeanor and her precipient witness to the aftermath of the assault. If the court would indulge me, I would just briefly read the entirety of that first complaint conversation, the first complaint itself, which is on trial transcript volume 6, page 42. The entirety of that conversation was 3 questions by Ms. Barrera to the victim and the victim's 3 single-word responses. First question, the witness testified, "Are you okay?" Victim, "No." Ms. Barrera, "Do you know anybody here?" Victim, "No." Ms. Barrera, "Did you give him consent?" Victim, "No." Everything else that Ms. Barrera testified to, the circumstances surrounding the assault, of course, that is considered first complaint testimony as well, but that was also her precipient witness to the actual aftermath of the assault. In the defense's brief, they do argue that the defendant was improperly prejudiced by the fact that Ms. Barrera testified to a 911 call that occurred, which in fact did not occur. However, the Commonwealth would just briefly point out that that testimony only came out on cross-examination. The Commonwealth did not present that evidence in its case in chief, and the defense heavily relied on inconsistencies between Ms. Barrera's statements, the victim's statements, and other witnesses' statements to put forth a fabrication defense and show inconsistencies and undermine credibility in those arguments, in those testimonies, excuse me. I can briefly go through the independent relevance of those other witnesses if the court would like. Ms. Calderon specifically, I believe, is the other individual that maybe the defense has the strongest argument was a backdoor first complaint witness, but she clearly was not. As I believe Justice Hodges pointed out, Ms. Calderon was a precipient third-party witness. She testified to facts very different than what Ms. Barrera testified to. Ms. Barrera testified that when the door to the bedroom opened, Ms. Barrera entered the bedroom and had that conversation with the victim, whereas Ms. Calderon testified that she immediately turned around and went back out into the living room and started filming the interaction. The purpose of her filming that, as she testified to the jury, was she was trying to find out who we now know as the co-defendant, try to find out his name, get his image recorded on her phone, and we know that that was then later used by the police to identify the co-defendant. So there was independent, relevant reasons for her testimony to be admitted. Mr. Arne's testimony about those text messages with the defendant before and then after the assault were relevant to show the defendant's frame of mind and any possible intent in planning the rape by joint venture here. Ms. Heda's testimony was again relevant to talking about confirming the defendant's identity. The sane nurse, we know that is under Dargon. Sane nurse testimony is absolutely admissible where it is necessary to establish a foundation and background for how DNA evidence was collected. And of course, the victim is the precipient complaining witness. Her testimony is indisputably relevant here and in fact necessary before the court can consider and the jury can consider first complaint evidence.
Do we know why the condom wasn't tested?
I do not know why the choice to make, to test the condom, to not test the condom was made. I believe that the Commonwealth put forth the theory that it didn't matter the inference was strong enough. This was a single-bedroom apartment with a single bathroom. The victim was laying in the defendant's bed through the entirety of the after party, or just about the entirety of the after party. So the Commonwealth felt that it was a strong inference, as it seems the jury also did, that condom that the victim testified the defendant wore a condom was a strong enough inference to draw the jury's attention to the fact that that condom could have been related to the assault. We know that the jury was properly instructed, that attorney arguments were not evidence to be considered, and we know that they followed that instruction from the court that was properly given because they split their verdict here. They clearly did not blindly follow every argument that the Commonwealth made because they split their verdict. The defendant was acquitted of one of the charges, convicted on the other. If the court doesn't have any other questions about the closing argument, I will just briefly touch on the ineffective.
Just one question. I mean, isn't it, apart from the prosecutor's argument, couldn't the jurors, without any suggestion by the prosecutor, draw their own inferences?
Absolutely.
From the
Absolutely.
evidence? So if there's evidence of the condom being in the trash, that they could use their own minds to link that to the crime, couldn't they?
Absolutely. They absolutely could have linked that and made that inference, made that logical conclusion by themselves, and it was, as I believe Justice Meade pointed out, completely proper for the Commonwealth to help them put those puzzle pieces together, create that coherent picture of all of the events that took place that evening. Briefly on the ineffective assistance claim, as the justices previously noted, there is no affidavit of a hypothetical witness before this court. There was no motion for a new trial. So it is impossible to say that indisputably on the record there was any ineffective assistance here. It was a strategic choice for the defendant not to present his own expert witness here. In preparing for argument, I also realized if the court were to refer to page 19 and 21 of the defense record appendix, the defendant actually did submit a notice of an expert witness on August 8th, just days before the trial, and then on August 11th withdrew that notice and then decided that they would not present that expert. So clearly this was contemplated by the defense attorney.
What was the strategy?
The strategy, I'm sorry?
You said it was strategic.
Yes, the strategic decision, I believe I believe that the defense was, again, the DNA transfer, and they were able to adequately question and cross-examine the Commonwealth witnesses about that transfer. It was a lengthy and fulsome cross-examination, and the defense really put forth that argument strongly in argument to the jury. So I don't think, it seems to me, I would infer that the defense attorney felt that adding a third expert witness to that, hiring their own, was not necessary when that defense would be adequately put forth through the Commonwealth witnesses. If the court has no other questions, I will rest on my brief.
Thank you. Thank you both. We'll take it under advisement. The next case is 25P81, Commonwealth versus ROBBINS. Mr. Lown.
Thank you. For Mr. Robbins. I'm actually going to talk about the decision to call the brother. So I'm gonna start there as far as my argument goes. It was manifestly unreasonable both to call the complainant's brother, Anthony Medeiros, as was the manner in which his testimony was handled. Calling one's own witness imposes responsibilities. Counsel must know what the witness is going to say, the limits which can be put on his testimony, and must seek to interview the witness prior to trial. In her affidavit, provided that she never interviewed Anthony Medeiros. She apparently relied on statements he had made 5 years prior to trial. If the sole purpose of Mr. Medeiros' testimony was to establish KM's motive to lie, that evidence had already been entered through KM.
But didn't he also testify that he never saw any abuse in the home?
He did.
That's pretty significant, isn't it?
Sorry?
That's pretty significant, isn't it?
That he didn't witness the abuse. It was never alleged that he was a witness to the abuse. The allegation in this case was that these were two things which happened only allegedly involving Mr. Robbins and KM in 2 separate incidents where he was not present.
But that might be a good reason to call someone to say, yeah, I lived there in the apartment. It's not very big, and I never saw anything amiss here. Isn't that important testimony for the defense?
I don't think that that goes to the crux of the accusations, where those accusations were time-specific and limited to these 2 particular instances in which it was never alleged that Anthony Medeiros was around. So that would have been where nobody
I thought
claimed.
didn't he sleep in a bedroom right nearby?
He was 5 years old at the time and slept in a bedroom, I think, down the hall, or as you suggest, close by to her bedroom. So I wouldn't expect him at that time to prove a negative, I think, weighed against the damage that he was poised to do. And that damage is something I wanted to
Wasn't there
get
also
at.
potentially some conflict between how the victim had told the brother about the New Year's Eve incident, that whether it was by text message or whether it was in person, wasn't that something that counsel could have been exploring?
So the KM provided that she told her brother, she said she didn't recall exactly, she didn't think it was that night, it might have been over text message, where Anthony Medeiros, the witness who was called, as you suggest, said that he talked to her, she explained what had happened, and he gave her this, he gave her a hug to console her as a result, which I think the thrust behind this argument I'm trying to make now is that that was powerful evidence which refuted, rather than provide a contradiction as to something that happened
The defense
15 years earlier.
The defense was fabrication, right?
Yes.
And the idea being that the victim was trying to garner sympathy in the wake of her breakup with the boyfriend.
Yes.
And that evidence came in through Medeiros,
Through KM.
but also Medeiros.
Yes, also Medeiros, cumulative of...
Or supportive of the defense.
Weighed against, this is the argument that I'm trying to make with regards to this portion, weighed against the damage that Medeiros could do, which was precisely to cut down.
Excuse me.
Yes.
Failed strategies don't necessarily equate to being manifestly unreasonable.
Labeling something as a strategy doesn't save it from being...
We didn't call them by accident.
The allegation here, and also there is an unresolved factual dispute where Mr. Robbins says he wasn't consulted about this. This person, essentially hates me, and that he believed that Mr. Medeiros and the mother were colluding to fabricate these charges against him. And put in that position, whether one has a strategy or not, if it's implemented ineffectively, that does provide grounds for relief, because, as stated, he was positioned to cut down her central theory, which, as you point out, was, Your Honor, was fabrication, and that the reason for the delay was because it didn't happen. And so what he was able to provide was to corroborate the believability of that, as well as provide a reason for the delay, which was that, as he said, she wasn't ready to talk about it. So, weighed against the damage that he was set to do, and the fact that any evidence he could provide would be merely cumulative of, if you already have that motive to lie evidence through KM, you wouldn't put a witness on the stand who is powerfully positioned to do harm to your case. If the purpose was to establish that she had misstated to the police who the first complaint witness was, that was already put in through KM. You wouldn't call to the stand and then, on cross-examination, fail to limit his testimony to its permissible scope. Because on cross-examination, and this time we're talking about cross-examination by the prosecutor, so when questioned by the prosecutor he was then allowed to go into all of this hearsay, which KM had provided to him, namely that she had told him about this closer in time to the actual event, that she looked like she had seen a ghost, that Mr. Robbins had raped her, that she didn't want to get into the details, that she delayed telling.
Where did it say that he said that it looked like the defendant had raped her? I didn't catch that. Where in the transcript was that?
Anthony Medeiros provided that that was something which KM had said to him as part of this telling.
Where in the transcript was that? I must have missed that.
Pardon me, Your Honor. That was something which was in the, I'm sorry, that goes to my argument that his statements, meaning Mr. Medeiros' statements, were going to be predictably bad, very bad for the defense, because this was something that he had provided pre-trial to investigators. I apologize. It was not in the transcript, Your Honor. It was not in his testimony. This went to my argument that she could see, meaning trial counsel could see, here is a hostile, adverse witness that I'm going to put on the stand who can corroborate and cut down my defense of fabrication and who is overtly hostile to my client. And so in trying to get from him helpful testimony, which he essentially failed to do, when then next questioned by the prosecutor, she was unable to limit what he provided on through that elicitation, through that portion of his testimony, which was everything that I laid out in terms of substantiating and making KM's account more believable, which was highly impactful in a case that turned on credibility.
But counsel did have some success here, though, because there was an acquittal on one of the charges, right? And a required finding of not guilty on another.
Well, Your Honor, that was because, and I think this goes to my argument as to the fact that counsel wasn't, it's hard, I understand it's hard to listen and conduct a trial at the same time, but counsel was not listening to KM's testimony because KM testified to only 2 rather than 3 incidents of indecent assault and battery. So the reason why he was acquitted on that 3rd charge was because KM simply did not testify to a 3rd incident. And trial counsel, in fact, attempted to get her to start talking about the 3rd incident, whereas on the stand, KM then reminded trial counsel, no, as I said a few minutes ago, I only recall 2 incidents, I don't recall 3. So that was that acquittal. And then the other acquittal was, I believe, unnatural and lascivious acts with a child, and one of the, the elements just didn't fit the evidence. I believe one of the elements was that it had to be done in some sort of a public space, and there simply wasn't testimony on that.
Let me ask you this, and I'm not picking on you for this because I've seen this in some other cases recently. The complaint wasn't included in the record. Is there a reason for that?
In the record appendix?
Yeah.
I apologize.
Okay, I didn't know if there was some particular reason that it wasn't included. The other thing is there was okay, all right, that answers my question. All right, thank you.
Yes. My next set of arguments goes to the elicitation of evidence which made the account more believable. So I think the following is required of an effective attorney, which is that if one is impeaching a witness with a prior statement, do not make the impeachment statement worse than the witness's testimony, particularly if that impeachment statement can be used for any purpose, including its truth. And relatedly, do not affirmatively elicit testimony which makes a conviction more likely. Concerning the object of the assault, the failure to object to speculation and the perpetrator's identity, without trial counsel's cross-examination, KM testified on direct examination, she speculated and assumed that the assailant touched her mouth with a penis. With trial counsel's cross-examination,
Her testimony, despite her characterization of it being speculation, was not speculation. She can testify as to what she thought occurred and what was touching her.
so my argument with that is she can, as a percipient witness, she can testify to what she perceived. But she is not permitted to provide her opinion or make inferences from that testimony. So her saying that...
He explained that the first touching was with a finger because she felt the fingernail, and the second one was softer without a fingernail, and she believed it to be a penis.
That was her belief. She also testified that
So, I mean, that
her
boils
belief
down
may be so.
That boils down to an issue of credibility, not admissibility.
So and I'm not arguing admissibility. I did argue admissibility as far as stating that this was speculation. What I'm arguing right now in this moment is that trial counsel shored up and corroborated and made more believable the fact that this was in fact what occurred by establishing, one, that she saw a person unzip their pants, which she put in affirmatively through her eliciting that evidence, and two, that closer in time to the actual event, and 18 years prior, she had told an investigator that this was precisely what happened. So the question is, could better work have accomplished something material for the defense? And it's not whether she would have secured an acquittal without this conduct. It's whether she caused substantial prejudice to Mr. Robbins through the result of establishing supportive details which helped the Commonwealth to sustain its burden.
Can I ask you this? So if I understand, and tell me if I don't, there's no question of identity with the first assault. It was face-to-face, correct? And you're suggesting that by getting in this other evidence that counsel should have kept out on the second assault, he was deprived of an identity defense.
The piece of identity goes hand in hand with the piece of the defense regarding fabrication, because the defense's theory was that the account was vague and speculative, both as to who it was and as to what happened, and it was vague and speculative precisely because it did not happen.
There was no evidence of any other adult in the house for the second assault, correct?
Correct.
So why wouldn't it be a strategic matter for counsel to decide that an identity claim on the second assault would unnecessarily conflict with your overall theory of fabrication?
It does not conflict. Those defenses would be mutually reinforcing because she provided that the complainant did not see who it was speculative by her account as to what happened. And instead, what defense counsel then did on cross-examination in a misguided attempt at impeachment was to shore up all of those statements. And I pointed to some other cases where defense counsel apparently, as an attempt to impeach
You have anything else? All right, we're going to leave it there.
Okay.
Mr. Amaral.
Good morning. Excuse me. Good morning, Your Honors. May it please the Court. Chris Amaral for the Commonwealth. I'll start with issue 3, since that was the bulk of the defense's argument here. So, addressing Justice Allen's question about the controversy here between whether or not the victim had texted or talked to in person to her brother prior to Medeiros getting onto the stand. What we have here is this kind of back and forth. Yeah, maybe she says she talked to him, right? But what we have is, well, maybe I texted him, right? And that's what the fact finder would have had up until that point. maybe I texted him like I did with my friend who I also had told about this incident, right? What Medeiros does is, yes, he says, yes, I hugged her and, you know, I consoled her and stuff, but what that does is, one, he says I talked to her in a bedroom, but it also puts him in the room with her. So if, looking at it from the defense perspective, if I have one, you know, bit of evidence that says, well, this is how the disclosure went, which is the centerpiece of my defense of, you know, she's, you know, doing this because her boyfriend broke up and we want to know what happened here. If there's this huge discrepancy, you know, between I texted and I hugged her, I was there in the room with her, I would think that that would be something that I would want to put in front of the fact finder and say, okay, you know, this big piece of evidence, right, kind of blows up at least part of this story, or if you're looking at it from the defense perspective. To the allegation that he was potentially a hostile witness, hostile and potentially devastating witness, I think is how it's referred to in the brief. The Commonwealth explicitly did not put him as a witness. At trial, right before trial, the Commonwealth tells the judge, no, we're not bringing a first complaint, we're not bringing this friend, but we're also not bringing the brother. And specifically, the Commonwealth says he is not a viable witness for the Commonwealth. We're not putting him on because he's not a viable witness for us. So to say that he is a devastating witness or potentially devastating witness for the defense, where both the Commonwealth and defense counsel had access to the same pre-trial documents.
It does seem to be a little chancy, though, doesn't it, to put someone on the stand without speaking to him first? Shouldn't there be some kind of pre-trial preparation with a witness?
I think Your Honor is correct. I think it was a bit of a risk putting the brother on the stand, but I think given what she had before trial, which is Medeiros' interview with investigators, he testifies essentially to the same thing. He doesn't say I don't think he says anything different at trial that he says at with the investigators. And the most damning bit is, I was in the room, I hugged her, I consoled her, like she looked like a ghost, right? But that's exactly the same evidence that, if I'm the defense, like I said earlier, that's exactly the kind of the evidence that I want to put in front to say, well, she says he's not in the room, he says he is in the room, something is amiss here. So I think balancing out the emotional, she looked like a ghost, you know, I hugged her to console her, versus putting in this piece of evidence that further, from the defense's perspective, further erodes the victim's story here, I think was even without hindsight, or even with hindsight rather, without hindsight, makes it a reasonable, if not somewhat risky move. I don't think it was completely unreasonable to put him on the stand, given what the defense had in terms of evidence and the fact that the defense wanted to put this discrepancy out.
Well, do we even know what was meant by she looked like a ghost? I mean, that doesn't indicate she was sexually assaulted years before, necessarily. It could be in connection with the fact that her boyfriend was slipping away, someone who she cared about very much, apparently.
Correct. Yeah, that is something that, I hadn't thought of, admittedly. But yes, exactly. So that, she looked like a ghost was ambiguous. The I consoled her is more on point about, maybe, she's, but again, it could have been, I'm consoling her about the boyfriend, given that, and also, what I've just laid out, I think it was reasonable to put Medeiros in front of the fact finder. If there are no questions further on that, I will go to the other issues. So I think fairly quickly. So on issue 1 about the introduction of the defendant's height, a reading of the transcript kind of shows you what defense counsel is doing here. So she says, yes, you said that he's tall, right? And she turns to defense counsel, the defendant, and says, and in fact, he is tall. Everybody can see he's tall. He walked into the courtroom, everybody can see that he's tall, right? But she uses the height as a means of further eroding this story from the victim. So she says, okay, well, you're a small child, so naturally anybody who's, an adult looks tall to a child, right? But she's on a bunk bed on, I think it's like a foot off the bed or whatever, right? So she's saying, okay, so this guy, he's 6 feet tall, right? Allegedly, he comes down and he's puts his penis around where your face is, right? So he's this very tall guy and he's coming really down, and you don't say that he bent, that he bent down, that he crouched, that he did all this stuff, right? So it's clear she's trying to show the implausibility, and in fact, in her affidavit, she says, I'm trying to show how implausible this might have been, right? And so the introduction of the height here serves that purpose of showing the implausibility of the situation. Another thing is the height, unless you're arguing, as defense counsel kind of argues in his brief, that an identity defense was viable, the height doesn't really make much of a difference, because if you're, as Justice Meade pointed out, there's no issue of identity in the first count, because she's right in front of him. She says that he was, we were face to face. In the second incident, he's the only adult male, only adult period in the house. The only other people there are 2 other children besides the victim. In her, not at trial, but in one of the, I think it may have been the SANE report, she mentions that I kind of identify, she didn't say identify, but she says I could tell his rough fingers, he works for the cable company or something like that, and I could tell his rough fingers, I know his rough fingers or something like that, and they were on my lip trying to open up my mouth. So that would have also, if an identity defense had been put forward, that would have done significant damage to it if the Commonwealth had just brought that up. And the other thing, and I think perhaps even more damaging, is that in the SANE interview, she's asked, did your stepfather, the defendant, did he ever bring people over to the house? And she says, no. And she's emphatic about it. She says, never. He never brought friends. He never brought family, even when it's a cookout. So to put an identity defense forward would have made little sense for count 2 for those reasons. But it probably would have also diluted count 1, because now you have a bifurcated strategy of, well, she's totally lying and fabricating this thing. This thing never happened because she pointed me out. But this thing may have happened, and maybe there's a third party that did this thing, and now you've kind of got, instead of kind of marshaling the evidence totally in what I've kind of dubbed in my head as like this unified fabrication theory, like she's lying about everything, which is in fact what defense counsel does at trial. And on to, if there are no other questions on that issue, I think it's actually issue 2 now, the alleged introduction of the penis into the transcript when defense counsel is questioning KM about, did she or did she not see the defendant either unzip his pants, unbutton his pants, or see a penis. One, as Justice Meade also pointed out, she says the word speculation, but it's not, in fact, speculation as we would think. It's not, I think one of the cases that comes to mind is, I think it's pronounced Yates or Yetz or something like that, where like a brother-in-law is like suspicious of this guy who kind of knows has a criminal background, and he's suspicious of this guy who's sitting next to, I think it's his sister on a couch, and he says, oh yeah, it was kind of like shady, it was kind of like, so that was speculating because he didn't really have anything to go on. He was just, oh, I don't like this guy, he's kind of shady, or he's, there's something off about it, right? That's, definition of speculation. What she's doing here, she's saying, okay, an object, like something touched my lip.
She was more specific in her prior statements, right? That the fact finder did not hear during the trial, right? So,
Sorry,
isn't that correct? So, in other words, if defense counsel decided to probe this issue more, better work may have invited a disaster because the victim appeared to be, as counsel put it, dialing back her testimony from what her prior statements. So there's always a risk if she probed this too much that the victim might say, yeah, it was him.
Correct.
Because she did, in her prior statement, correct me if I'm wrong, but in her prior statement, she described seeing him in the room and like he was doing something with his pants. So she did get somewhat of a look at him.
Correct.
In other words, it wasn't some stranger, you know, an intruder coming in off the street. It was someone that did not alarm her in the room, right?
Correct. Correct.
So why probe that at trial
Exactly.
if it's a little ambiguous?
Right. And I just had a thought and it just left me instantly, sorry. But yeah, on that, and the other thing too is on the introduction of this, you know, not aside from the speculation language, again, reading the transcript, it's quite clear, again, what defense counsel is doing here. So like with the, you know, was he tall, you know, and all that stuff. What defense counsel here seems to be doing is saying, okay, well, you said in these prior statements, I think it was to maybe Detective Brianna, the three police reports are swarming around in my brain. So one of the police reports, she says, well, here you said that he had unzipped, that you saw him unzip his pants and that you had seen his penis, all right? Correct? Yes. But, and then she, later on in the testimony, she says, well, but you did not in fact see a penis, right? Your eyes were closed. You did not in fact see a penis. And she says, yeah, to my knowledge, no, right? So she says, I did not see a penis at trial. So again, if your goal is fabrication, to say that this whole thing doesn't make sense, saying, well, we've got these two, maybe three different versions of this. One, you've got, you know, you see him unzip his pants, you see him, you know, take out his penis, and now on trial you're saying, you know, that didn't happen. It goes along with everything else she said. She said, well, one, you said that you were digitally penetrated, and now you said that you were only touched. Well, before you said that you were that you had shorts and underwear on, and here you say you only have underwear. So it's, and she, if I remember correctly, it's kind of like fairly rapid succession that these questions are coming. So it's a train of questions coming to erode steadily, right? Or the strategy was to erode her credibility, and that's exactly what defense counsel says in her affidavit, that her point was to show fabrication, that these things didn't happen, that they were all impossible or improbable, and all of the tactics that are in contention here, just to me, you know, seem to be in service of actually showing, you know, that these are things that may or may not have happened. These are instances where discrepancy might break down this victim's credibility. If there are no further questions.
Seeing none, thank you. Thank you both. We'll take it under advisement. Our next case is 25P223, Commonwealth versus Martinez. Mr. Benyon. Excuse me.
To the presiding justice, and may it please the court. This case turns on two evidentiary rulings that we believe injected a high degree of prejudice, unreliable evidence into a credibility-driven case. Number one was the admission of against Mr. Martinez of the non-testifying co-defendant's confession to her mother under the joint venture doctrine, and the second is the admission of Ms. Negron's bad act narrative. And I'll just deal with the first issue. So the Supreme Court has already addressed this. When a co-venturer makes an admission and they don't testify, that can't be used against the defendant, even when an instruction is given, like in Burton. The Supreme Court said that is a step too far. It's too prejudicial. In this case, this is what happened. Now, the problem here is that the court took it through the joint venture Section 804 lens. And the problem with that is there's no evidence that this was a joint venture continuing. Usually a joint venture is just for the event. Once the event is done, the joint venture is done. If you need to show that there are cases that talk about that a joint venture can continue if the secrecy is part of the joint venture, but there has to be evidence of that. You can't just assume that, and that's the problem here. That's what was assumed. There's no evidence that the joint venture was meant to go beyond the assault if you believe that the assault occurred. In this case...
Let me ask you, so we're reviewing for an abuse of discretion, right?
For an abuse of discretion?
Yeah.
As the evidentiary standard, yeah. But if this is a confrontation clause, and so you're also looking at...
I'm going step by step.
Okay.
And the Commonwealth needs to establish the existence of the joint venture by a preponderance of the evidence.
That's true.
Okay. So the theory, you're correct. She didn't say, Mom, don't keep this to yourself. But the child has recanted.
I'm sorry, say that
The
again?
child has recanted.
Yes.
Okay, and she goes to see her, and she's in disfavor with her mother because of this, letting her sister be raped. And now she's trying to reestablish that relationship with her mother with the supposed goal that the mother's the one that's in the position to reactivate this, as the judge says.
To reactivate what?
To reactivate the investigation. Why isn't it a fair inference that she had gone to her mother to essentially attempt to have the mother no longer discuss this with anybody, especially the police?
Because the testimony was specifically that this was to rekindle the relationship.
Yeah, that was step one.
Yeah. But again, there's no evidence that this was part of the joint venture at the beginning. That's what I want to...
Well, there is a joint venture. You're not disputing that. Your issue is whether it was continuing.
It was continuing, yeah. And there's no evidence of that, and that's the trouble here. I'm not disputing.
No, I'm saying there is. My question is, why isn't it an inference that the trial judge and then eventually the jury can draw that she wanted to rekindle the relationship in order to keep her mother on her side because she's implicated herself and she's looking at serious jail time? Well,
the testimony was that she almost immediately went to the police anyway.
Yeah, it was an attempt to get her not to do that. It doesn't have to succeed to be an ongoing joint venture, right?
That's what we're discussing, yeah, whether it was ongoing. But again...
No, but I'm saying it doesn't have to be successful.
Oh, it does not have to be successful. I understand that. But it wasn't even... This idea wasn't even really probed when the mother was on the stand, and that's the trouble. There really is no evidence. It's coming in after the fact.
Right. Was there evidence that this is what the mom was trying to do, that she was trying to curry favor with her mother to prevent her from going to the police? Was there any evidence of that?
I didn't see any evidence of that. All I see is kind of the chaos of the drama that unfolded. If you believe the young girl's statement, the mother might have been trying to understand what was going on, but you also have, through this narrative, the overarching testimony of the breakdown of the relationship between the mother and the daughter, and when it is the only point that was testified to was that was the reason. It was to bring the mother and daughter together. Conditional on truthfulness, though, and that's what I want to point out. It's conditional on truthfulness, and that's why this is a confrontation clause problem, is because the destiny did not testify. There is no ability for the defendant or his counsel to confront
But
these
this all
statements.
goes back to whether or not there's a joint venture going on, because statements of joint ventures are non-testimonial for Crawford purposes.
I'm sorry, say that again?
All that matters for the basis of your argument is whether there's a joint venture going on or not. Because a statement of a joint venture is non-testimonial for purposes of the Confrontation Clause.
Right.
So-
But again, in this case, the issue of the Confrontation Clause is the defendant can't cross-examine this statement. It can't come in. Under Burton, even if there is a joint venture,
But if it's non-testimonial, then it doesn't matter. The Confrontation Clause is not implicated. So the lack of ability to cross-examine is a null set.
Well, I think that the main issue here is, yes, there was a joint venture, and I'm not disputing that. It's not ongoing. This is coming years later.
When do you say that ended?
I'm sorry, say that
When
again?
do you say the joint venture ended?
After the event occurred, the supposed assault occurred. Joint ventures don't normally continue on afterwards. In fact,
So what do we make then of the 2000 events that occurred in 2017 where the co-defendant had the sister recant?
How they had the sister recant. So again, with respect to a joint venture, and I'll just, let's see. So concealment can be part of a joint venture, but it has to be part of that original joint venture. The case law talks about the idea that after crime concealment is more of a natural consequence of having committed some wrongdoing, which generally does not extend the conspiracy or the joint venture. And that's what I'm trying to focus on, is you need evidence that that was part of the joint venture. Otherwise, the joint venture will always go as long as somebody can talk about it, and that's not what the case law says. A joint venture ends with the completion of the act that they're trying to complete. But just because they don't want it to be kept secret, or they want it to be kept secret, doesn't mean that it's necessarily part of the joint venture. Does that make sense?
It makes sense.
Can I give you a case law citation on that?
Of course.
Okay, so this is a U.S. Supreme Court case. It's right around Burton, 353 U.S. 391, but also Commonwealth versus Wadsworth, which I do cite in my brief. This is from the SJC 2019. Statements made after the joint venture ended are not admissible. And those two cases together, you need to show not every conspiracy is going to, or joint venture is going to continue in perpetuity. That's not what the case law says, and that's not what occurred here. There is no evidence that that was part of the original conspiracy. The evidence shows that the joint venture was simply to assault the young girl, if you believe her testimony. Once that occurred, the joint venture was done. And that's why it's such a problem when you just kind of come in and call this a joint venture continuing when Destiny speaks with her mother. This just looks like...
It absolutely could be continuing, though. But it seems to me the question is, and it goes back to the judge's thought process, where I'm looking at Volume 5, page 187, where he says that the co-venturer was trying to enlist her mother's loyalty so that she would not speak up. Now, if that were true, then it seems to me that the judge did not err and that the evidence should come in. But I'm just not seeing where that's in evidence.
That's my point. It's not in evidence.
Does it have to be? Or can the judge infer that from the evidence that that the jury had already heard?
It does. You're right. It needs to come in as evidence. You can't infer that. And in this case, the judge
You can or cannot?
Cannot infer it.
Okay.
And the judge does a two-step process here that is, I think, backwards. What the judge says is he infers that, and then he says, but I'm going to instruct the jury that they have to find that before they can ultimately move on. And the judge does instruct them on that, but there's no evidence. That's the problem here. And then we move forward, and it's, so the joint venture does not continue. And when you bring in these sorts of statements, especially when I get to Ms. Negron's testimony, when you just ask a jury, well, we need you to find that there's a joint venture before you can move on to the issue of whether the statement comes in, you've placed the defendant in such a problematic position that the jury is almost inevitably going to infer the negative. They're almost going to infer propensity or bad act. And now I understand that the Commonwealth always comes back with, well, the jury was charged and the jury always is meant to, or the law always presumes that the jury does what the judge asks. But I started off this with talking about Burton, and Burton is a nice example of when that doesn't happen. Sometimes there are things that are so prejudicial that even when you ask a jury to ignore it, the law has to say that it's just too prejudicial. That's what Burton says. And in this case, Miss Destiny's testimony to her mother, the mother's testimony comes in. We're not talking about the fact that, it's not a specific identification of this defendant. It clearly is. The defendant didn't, or the Commonwealth didn't argue that it was somehow not pointing the finger at the defendant. It clearly was, and that's the problem. The defendant can't really answer these problems, and that's why it is a confrontation issue. Are there any questions about that first part of? So I'll move on to the second issue then, and that is my battle with bad acts evidence. Here's the problem. I don't think I would mind so much. I want you to look at the pleadings in the record appendix, and this is what always happens in these cases. The government comes in with a generic motion that lists the exceptions to the hearsay rule, and then they don't ever explain anything about why they need it or how they're going to avoid the propensity problem, and then the judge always just writes aloud on the motion, and then I am stuck with a standard of review that is difficult. You're not the first judges to deal with this, but I want to read to you something from the Sixth Circuit Court of Appeals, the Federal Sixth Circuit, who have addressed this, and they see the problem with this type of evidence coming in. And noted also, I'm quoting from also Judge Easterbrook, probably one of the best appellate judges I've ever read. Other bad act evidence is too often admitted almost automatically without consideration for the legitimacy of the purpose for which it comes into evidence and for which it is to be used. Allowing a prosecutor routinely to introduce prior bad act evidence in a case in chief without demonstrating relevance to some concrete dispute between the litigants creates needless risk that the conviction will rest upon the forbidden propensity inference. And
I guess the line you need to draw is between propensity and pattern. If it's relevant to a pattern, then it's properly admitted.
So pattern isn't actually what it's modus operandi. It's the idea that is so unique that it actually does.
That is one reason to admit it. Motive, intent, pattern of conduct, not just modus operandi.
But the problem is, and I put in the older SJC cases that talk about the real problem with this sort of stuff. And again, I understand that the jury is always instructed on this, but there are issues that are so prejudicial that just giving a jury a instruction is not going to do it. This type of propensity inference is horrible. Ms. Negron testified to things that just have nothing to do with the overlying offenses, the indictments in this case.
She was the same age as the other victims, right?
Roughly the same age, not the same age. They were much younger.
It was the same location, same house, same room. The victims were all the same age 14 or 15, all close relatives or close friends of the co-venturer. I don't think that has
That sounds like
similarity.
propensity to me.
Thank you. Ms. Paris.
Good morning. May it please the court. Molly Paris on behalf of the Commonwealth asking this court to affirm the defendant's convictions. Starting with the first issue, Santana's out-of-court statements were properly admitted where they were made during and in furtherance of the joint venture. Judge Wall here had an extensive voir dire with the witness, Ruse Marte, and engaged with extensive arguments from the parties before making his decision on the record. He found that the joint venture was continuing because it was concealed. I think counsel's interpretation of when the joint venture ends is too literal. The fact that the crime, the rape of CR had ended doesn't mean that the enterprise had ended. And I think Judge Wall could properly infer, and the jury did so by their ruling here.
So let me, does the conclusion of concealment need to be explicit, or can it be implicit?
I think it can be implicit, and I think here the evidence that supports that reasonable inference that Santana was trying to, in the words of the case law, would frighten her into silence, was the fact that the mother, Ruse Marte, was aware of the abuse. She had encouraged CR to report this, I believe in June 2016. CR had then recanted at the request of Santana in October of 2016. And so here we have a situation where the mom is aware of the abuse. She had previously encouraged her daughter, CR, to report the abuse, and Santana had successfully thereafter encouraged and succeeded in having CR recant. So there's still this open question of
The
whether—
inference being that she was trying to maintain the status quo.
Exactly, yes. And so understanding this is years after the abuse, the rape had occurred, there was still no prosecution, there was still no arrest. It was still a lingering question of whether CR would go back to police, whether she would confide again in her mom, or whether Ruse Marte would go to the police herself, where again she was aware of this abuse, having learned it a few years prior. And again, I think this case is wholly distinguishable from White, where in that case the co-venturer essentially was saying, I didn't do it, she did it, and those statements were made to exculpate the co-venturer, whereas here we have Santana essentially making an admission to her mom and hoping that her mom will keep it in silence.
Well, yeah, but I mean, it was an admission that fully implicated the defendant, right? I mean, they weren't. She wasn't admitting to committing the crime alone. She was saying, by her description of it, she was necessarily saying the defendant did it.
Sure, but she was also implicating herself, which is different than in White, which is cited in my brief, where the co-venturer says, quote, I didn't do it, she did it, and placing all the blame on the co-venturer. So regardless of whether she's making an admission that involves the defendant, it's also involving herself and providing some justification, whether that is to be rekindling this relationship with her mother or not. I think Judge Wall did and properly found that there was this reasonable inference that the joint venture was continuing, it was ongoing, and that there was this desire from Santana to keep the mother silent, where CR, I believe at the time, was still a minor.
So, all right, so just so I'm clear from the Commonwealth's position, you would agree that there's no express testimony that the co-venturer wanted to keep the mom quiet and not reveal anything to the police,
Correct.
right? Okay.
And I think this court would be hard-pressed to find a case where a co-venturer tells someone else, a third party, you need to be quiet, like, shh, about this. You know, I think it's—
Well, that's not, I mean, there's plenty of cases that say that. I mean, if after a bank robbery, you know, I have to hide the gun here, don't tell anyone it's here. I mean, that does happen all the time, doesn't it?
Sure. So it wasn't express, but I think it certainly is a reasonable inference and can be implied.
But you're saying there is evidence where the inference can be drawn that that's what the co-venturer had intended by being truthful with the mother and telling the whole story as to what happened.
Yes, and I think that's borne out by the testimony and the timeline of events where the rape happens. Then the mom learns about it from CR, encourages her to report to police, and then CR does report to police, and then she recants months later at the request of Santana. That's all in the record. And again, I would note that Judge Wall did make proper limiting instructions, and I think the case law makes clear under DePina, quote, the evidence properly admitted under the joint venture exception to the hearsay rule does not implicate the Bruton rule. So I don't think we have that concern in this case. Unless the court has any further questions, I'll move to the Prior Bad Act issue. In this case, the prior bad act was properly admitted where it was relevant and probative to show the defendant's sexual interest in young female children, all of whom were either family members or close family friends to Santana. They were all the same age or in the same age group. All the abuse happened at 202 Norwell Street. And just going through the evidence briefly, at the first trial, there's a fight between the defendant and Santana. He then gets into bed with the two victims who are 10 and 11. That being the victim, or excuse me, Santana's daughter and Santana's family friend, who's Negron's sister, digitally rapes them. And then at the second trial, he rapes Santana's sister, CR, at a party, also at 202 Norwell Street. So again, here where all of the uncharged conduct was relevant to this pattern of abuse of people close to Santana, and where it wasn't unduly prejudicial, where the uncharged conduct was not substantially similar to the charged conduct such that the jury would engage in propensity thinking, where there was proper limiting instructions. I think there was no abuse of discretion in Judge Squiresley and Judge Wall admitting this. Unless the court has any further questions, I will rest on my brief.
Thank you. Thank you both. We'll take it under advisement. Want to take a break or
Do you? I
do
can
another
keep
one?
going.
Do you want to do one more?
Sure.
Yeah. Excuse me. The next case is 25P772, Suburban Electric Contracting versus SEFER OZDEMIR. Mr. Curran.
Good morning. May it please the court, Thomas Curran for the appellant SEFER OZDEMIR. We're here on appeal on an issue that stems back to a judgment that was issued in 2021, wherein my client attempted to, a judgment and execution issued in 2021 for a certain amount of money. My client attempted to pay that judgment in full at a hearing in December of 2022 and was refused by the judgment creditor. And from that point, for the next 2 years, continued right to this day, the judgment creditor refuses to accept payment of that.
Could you address the issue that was brought up by opposing counsel that some of the issues are waived because they were not addressed below?
All of the issues, well, I'll deal with the 59E issue that they attempt to claim that it's waived. It was never brought as a 59E motion. There was no motion to amend the judgment ever brought. In fact, if Your Honors look at the transcript in December 21, 2022, that was the first time we were in court. The transcript is replete with arguments from counsel that there is no provision in the law to bring a motion for attorney's fees. You just can't do it. And he goes on and argues with Justice Reese about how he can't bring a motion for attorney's fees. Eventually, after he was ordered to bring some motion to the court, he did bring a motion for attorney's fees in response to our motion for a protective order in the summer of 2023, And it was only in response to our motion for a protective order because he was attempting to do Rule 69
Was
post-judgment
this issue
discovery.
raised in the appellate division?
It was. It was raised and briefed by both parties. It's throughout the briefs.
Okay, so how is a Rule 59E a motion for funds, for attorney's fees?
There's no provision in this judgment for post-judgment attorney's fees. The only way that he can get, or the only path that he would have had to add on attorney's fees onto this judgment was to move the court to amend the judgment.
Why isn't it part and parcel of the judgment? Let me ask it differently.
Yeah.
Do you have a case from anywhere that says you need to file a 59E to request attorney's fees?
No,
Isn't that a problem?
no, because there's 59E is to amend the judgment.
I know what a 59E is.
Right.
I'm asking you, do you need to file a 59E to get attorney's fees?
You do if your judgment does not provide for post-judgment attorney's fees.
And what's your citation to legal authority that supports that?
Well, it's definitely, it derives originally from the cases on the merger doctrine and Dwight v. Dwight and all the cases on the merger doctrine follow that all of the provisions in the underlying contract, and again, that's where this...
Let me ask you about that, because the case seems to hinge on what the parties agreed to in the underlying contract. I didn't see the contract in the record. I see references to the contract and references to a trial stipulation, but I don't see the contract. Is there a reason that's not in the record, or am I just not seeing it?
The statement clause is in the first appellate division decision on attorney's fees.
But the contract itself isn't before us, right?
No, it's just the clause in that decision, because originally, when the trial was conducted, the jury awarded $17,000 and change in damages, but no attorney's fees. Attorney's fees were denied by the trial court. It went up to the appellate division, and the appellate division said no, because the parties had a contract that says, quote, finance charge of 1.5% per month will be charged to all balances over 30 days with attorney's fees, end quote. So the appellate division sent it back down to the trial court and said, no, you have to add prejudgment attorney's fees. And if you want, and in that decision, which is in the record, the appellate division specifically called out the judgment creditor to say, if you want appellate attorney's fees, meaning anything after the trial, you need to ask for those here in the appeals court, appellate division.
But back to what I was saying before, though, you're asking us to construe terms of a contract, which would be de novo, right? But we don't have that contract before us, so I'm wondering how we can do what you're asking us to do. Don't we have to put eyes on the contract to construe it?
Well, that's the appellee's issue, not my issue. I'm not asking the court to...
You're the appellant, so it's your, excuse me, it's your responsibility to put an adequate record together for the appeal.
Well,
Rule 18.
I agree with you, Your Honor, obviously, but it's the appellate division's original determination that the appellee relies upon. We don't rely upon that, and
Isn't there a provision in the contract for attorney's fees?
yes, it says, and the statement, which is quoted by the appellate division, which is in the record. It says, and I quote, "Finance charge of 1.5% per month will be charged to all balances over 30 days with legal fees," end quote. That's all it says. And that under the merger doctrine, that merges into the judgment. If he wanted to have post-judgment attorney's fees, then he would have had to have that in his judgment. That's the merger doctrine. And
Okay, so your position is, and that's why you referenced it, that if the appellee is going to rely on the language of the contract, it was up to the appellee to include that in the record. You're saying the merger doctrine says that the judgment fixed the rights of the parties, that's it.
that's correct. And that's the law, is the judgment fixes the rights of the parties, and the judgment provides for post-judgment interest, but it does not provide for post-judgment attorney's fees. And that's the problem with this case, is that the appellee takes the position that any post-judgment attorney's fees, until they're paid, they're entitled to not refuse to accept payment. They don't have to apply to a court for an award of attorney's fees. They don't have to have anybody oversight with the attorney's fees. In fact, they're entitled to attorney's fees. It's the appellee's position that they're entitled to attorney's fees on this judgment that it has been issued by the most recent judgment issued by Judge Reese, which specifically states no further interest will be charged. And Judge Reese specifically states her tolling order is in full effect, and the judgment itself says 0 interest. But the appellees in their briefing are arguing that the interest is still accruing because of that pre-judgment contract of almost 10 years ago. And the merger doctrine provides that that contract and the provisions of that contract are over. And you're left with your rights under the judgment. So, and
Do you have any cases that say that a request for an attorney's fees merges with the judgment?
there are
Just one.
the provisions.
Can you cite me a case?
Well, the not specifically attorney's fees, but provisions of the note.
Well, I'd like one that talks about attorney's fees.
No.
So there's no legal support for your
no.
argument.
Well, there is. That because
Well, what is it? What is it? Is it a rule? Is it a statute? Is it a regulation?
it's all the SJC merger cases deal with the specifics.
Do any of them deal with attorney's fees?
No, there's a case that the appeals court decided that talks about attorney's fees when it specifically indicates that the parties, the language in the particular contract or the note, whatever it is, specifically indicates the party's intent for post-judgment attorney's fees to be recoverable. Then in those circumstances, that's the Robbins v. Krupp case. But that's not the case here. This language doesn't specifically contemplate future collection purposes. In that case, the difference between that case, Your Honor, was that the provision was in the default clause of the contract, and it came right after a provision where there was an agreement for judgment. So clearly the parties, the court found, clearly the parties understood that there was a contemplation that there would be a judgment and a default on that judgment thereafter. So the appeals court found that there was a contemplation of future attorney's fees.
Okay, so if I understand you correctly, you're saying that your client never agreed at any point to pay post-judgment attorney's fees?
Correct.
Okay.
And that's not, and that's,
And even though the appellees point to this language, finance charge of 1.5% per month will be charged to all balances over 30 days with legal fees, that there's no reference in there to post-judgment legal fees, A, and B, the judge cut off any further interest anyway. So how can there be legal fees in connection with interest that's not even accruing? Is that essentially what you're saying?
no, what I'm saying is that the attorney's fees were never agreed to in the contract, and the general rule under the merger cases is that there is no further reliance upon the contract terms. You can't pull a term out like legal fees or any other term out of the contract and take action on that if it's not incorporated into the judgment, because it merges in the judgment. The only exception to that is if this, in the Robbins v. Krupp case, where they found that, well, this language contemplates a judgment, and then it contemplates default on a judgment, and then it says any and all, or it says any, and the court found that that meant all attorney's fees. We don't have that. That language is not in this. This just says balances over 30 days will incur interest and attorney's fees. So it doesn't get to the exception to the, and that's the issue.
Okay.
And
We're going to leave it there. Thank you.
Okay.
Mr. Nathanson.
Good morning, Your Honors. My name is Alvin Nathanson, and I have with me my young associate, who is the author of the brief, his first brief. In any event, may it please the court. Of particular note in this case, and it's an unbelievable case that's been going on for 10 years, starting off with an $18,000.
Why not take the check for the $65K and then seek attorney's fees?
Well, what happened as far as why I couldn't take it was, I've never seen anything like that in all my many years of practice. I filed a motion for a special process server.
Yeah, and they wanted to avoid that by paying the judgment.
What was that?
They wanted to avoid the sale of the business.
Oh, well, that's the issue. Yeah. He did not, because what happened, and just backing up a little bit, what's not mentioned is that there was a second judgment in this case after the first appellate division decision. That second judgment ended with pre-judgment interest, post-judgment interest, pre-judgment legal fees, post-judgment legal fees. And what happened is they took an appeal and it lingered for God knows how long and never perfected it. So we had to come in with further motions for legal fees and interest. And that's why the third judgment, which is the one before Your Honors, is the issue before this case. There's an old doctor, when I first started going to law school many years ago, we used to call it res judicata. Now it's issue claim preclusion. The second judgment included it, both pre-interest, pre-judgment, post-judgment interest, et cetera. Now, what happened at the tender, the so-called, first of all, there's no such thing in Massachusetts law as a post-judgment tender. What happened is, on a motion, are you ready for this? On a motion for a special process server, he comes in on the day of the hearing and hands me a SIR reply, purportedly trying to make a tender. But because of the contentious nature of this, and without any notice, I could not accept it because of my 60 years of practicing law. I learned one thing: the client makes the decision as to whether you settle or not. I had no authority. Matter of fact, I think it was contrary to the.
Well, I'm sorry, I got you off track. So,
well,
can you help us out with which claims do you say are not properly here because they're waived?
Sure. The 59E claim was never raised in the trial court, and it was never raised in the appellate division. If you notice that the appellate division, none of the appellate division decisions ever mention it.
He said he couldn't raise it in the trial court because it's a post-trial motion.
No, it was never raised. What he raised, if you look at the post-trial motion, what he raised was the merger doctrine, not the 59E. That's the merger doctrine is different than, obviously, the 59E. 59E doesn't apply because the issue, you want a case to end. You don't want to have an adjudication of the merits and then have a separate case after that for an adjudication of the interest and the post-judgment or the attorney fees. Of course, interest by statute runs anyways, post-judgment. But as far as the merger doctrine, the appellate division got it right. What they said, it's collateral to the merits of a case. When you try a case, you try it on the underlying liability. You don't try it on the legal fees, and you don't try it on the interest. Matter of fact, interest is generally a perfunctory issue that a clerk takes care of, and and that's exactly what happened here. Again, the merger doctrine has nothing to do with this particular case. Now,
So what is the authority that you're relying, what is the authority that you are relying on for post-judgment attorney's fees? What's the source of that?
well, first of all, as I said before, Judge, it's already been determined by courts in this Commonwealth. Number one, the first appellate division case held, we're entitled to it.
Then why was it taken up again?
Why
was it taken up again? If it really was res judicata, why was it addressed again by the court?
Because I asked for more.
Okay, all right, now we're getting somewhere.
Yeah.
So what is your authority for the additional legal fees?
The additional, because it says, as my brother quoted, until paid in full. Interest runs, post-judgment interest runs until paid in full, legal fees runs. That was never contested, by the way, by him before any judge. This is the first time I'm hearing about
So are you disclaiming any reliance on the contract then?
No. The appellate division decided, this appellate division said it was by contract and by trial stipulation. As Your Honor knows, a trial stipulation is conclusive and binding on parties. And that was the first appellate division, and that was never challenged.
All right, this goes back to my question that I asked your brother counsel. We don't have that contract before us, and we don't have that stipulation before us. All we have is references to them. Can we make a decision relying just on that?
Yes, I think you can, because it's issue preclusion. It's already been adjudicated, number one, by a court in this Commonwealth, and the parties both have also agreed to it. This was a trial stipulation, and that's in the record.
That was the second judgment that it was in?
No, it was in the first judgment. The first appellate division judgment.
And the second one,
legal fees and interest.
And the second one was
was
not appealed.
The second one entered with it.
Was it appealed, the second one?
The second one was the one where after the first appellate division, we came running in and we said we're entitled to more post-judgment interest and legal fees. And that was entered, and although he appealed, tried to appeal it, he never perfected it. That was entered before the third judgment.
The second judgment was not appealed.
That's right.
Okay.
It was not opposed. He did not oppose. That's why it's issue preclusion or claim preclusion. His other arguments, I'll rely on my brief about discretion of the judge. I mean, judges have tremendous discretion on the amount of legal fees. I think I've addressed the two.
Did you want to speak
the
to
two
the
arguments?
you want to speak to the issue of excessive delay?
No, first of all, that was never raised either, too. And there's no time period for coming in for the filing of judgments, for post-judgment legal fees and interest. Interest keeps running automatically. And post-judgment, where is his authority that somehow or other and by the way, obviously the judge that entered the third judgment did not agree with him because she did award, I think it was $11,000 or $12,000 or something, some small amount of legal fees. And the appellate division affirmed that too. But again, that's not a valid argument in my opinion. Now, one thing I want to bring up, and I just want to mention, is that about this so-called tender. You obviously heard my little dilemma, but the problem was that first of all, there's no such thing in Massachusetts as a post-judgment tender. But secondly, what happened in this particular case, it was not a tender. It was a tender of the second judgment amount, which included interest, post-judgment, and post-judgment fees. But when it came to the legal fees for the post-judgment, that after the second judgment, he refused to pay it. I cite in his reply brief, pages 8 and 9, where he says, quote, "The appellant's tender constituted the full amount then due of the final judgment and execution," that's he's talking about the second judgment, "because as discussed throughout, the final judgment made no provision for post-judgment costs or attorney fees. The legal result of a plaintiff's tender is that the final judgment was satisfied." What he's telling you in so many words is he was willing to pay the interest post-second judgment, but not legal fees, which he's still opposing to today. But again, that's collateral as to the judgment. That's something that juries and, the merits of the case don't deal with. Interest keeps running by statute. Even post-judgment interest keeps running by statute until paid. And the same thing here with the legal fees. Legal fees remain. And why they didn't pay the $11,000 has always befuddled me because this was a 10-year-old case. In all my 60 years of practicing law, I've never seen anything like it. And now the judgment is into the 100,000s, which is outrageous. As a matter of fact, I use this case as an example to try to convince clients to settle, because I just don't understand it. But in any event, I don't want to take any more of your time. Okay. I would ask the court to affirm the two judgments of the appellate division and to affirm this judgment, and let's put an end to this case once and for all, because if he's right, what that means is we'll still get our money under the underlying judgment. But does that mean that I have to sue again for another judgment seeking legal fees? By God, cases have to end, and they have to end hopefully with one judgment. And then, well, thank you, Your Honors. Appreciate it.
For your associate, I realize this was your first brief, but for your next one, or one that requires a summary of the argument, take a look at Rule 16A8, when it says you can't merely repeat the argument headings.
I'm sorry.
Thank you. We're going to take a break. Our next case is 25P 1068, Jeanette Vivas versus EasyCater Incorporated. Mr. Solomon.
Good morning, Your Honor. Joseph Solomon for the plaintiff appellant, Jeanette Vivas, and may it please the court. The Superior Court erred in granting summary judgment to defendant EasyCater because by the defendant's own statements, it terminated Ms. Vivas' employment based on both non-retaliatory reasons and protected conduct under the Massachusetts Equal Pay Act, or MEPA. And it's for a jury to determine which of those reasons was the but-for cause of her termination. The jury could also determine, based on the evidence, that the non-retaliatory reasons given by the defendant was a pretext for retaliation. And for all of these reasons, this court must reverse the Superior Court's decision. Now, Ms. Vivas engaged in two protected conducts under MEPA. She inquired into her own wages and into the wages of a male coworker, and she also discussed her wages and the wages of her male coworker with her supervisors, and those are both independently protected conducts under MEPA. But I want to focus on that second protected conduct because by the defendant's own statements, that was clearly one of the reasons for her termination. But first, let's just talk about MEPA for a moment. MEPA was amended in 2018.
But wait a minute, doesn't there have to be, something beyond the plaintiff's own view of the circumstances? Doesn't there have to be some independent evidence that supports that?
Oh, certainly. Sorry, Your Honor, but supports what, Your Honor?
Supports that the reason for her termination.
Yes, Your Honor. On page 573 of the appendix, after she was terminated, the day after, she asked the HR director, Janine Allo, who was consulted on the termination. There's no dispute about that. She was consulted prior to the termination decision. She asked Janine Allo, "Can you explain to me why I was terminated?" And Janine Allo told her, and I'll quote, "You accessed information that was confidential to review for your own information. You then used it in your conversations with your director and manager, misrepresenting the source of the information. We do not publish salaries at EZCATER. It is protected personal information. Any use of personal and confidential information, even looking at it and not using it, is a breach of the standards of the IT department. There is no reason for you to access the form when you did, other than for your own information. That breach is serious and warrants termination." So the company there gives several reasons, not just one, for the termination. One of the reasons was accessing salary information for her own purpose, but another reason, very clearly stated, was using it in a conversation with a director and manager. Now, that is a plain, almost verbatim protected conduct under MEPA. In 2018, MEPA was amended to make it unlawful for an employer to require as a condition of employment that an employee refrained from inquiring about or discussing information about either the employee's own wages or about any other employee's wages, and also made it unlawful for the employer to discharge an employee because the employer disclosed the employee's wages or has inquired about or discussed the wages of another employee. And it also made it unlawful for an employer to contract with or make any conditions of employment to exempt itself from this chapter, from this subsection. This is a subsection of the Wage Act. But an employer, the legislator recognized that there may be employees like Ms. Vivas who had regular access to salaries, because Ms. Vivas, one of her job duties was to go in and change people's salaries information. So it also said employers may prohibit employees whose job duties or job responsibilities require or allow access to other employees' compensation information from disclosing such information without prior written consent from the employee whose information is sought or requested. So we have to reconcile these provisions with the facts. Now, EasyCater had several policies that talked about salary information and compensation information. They had the written information security policy and an acceptable use policy. But these were generally applicable policies to all EasyCater employees, not just to employees like Ms. Vivas. So these were not enforceable under MEPA because they conflicted with the provision I just read to you. A company cannot restrict employees from discussing or disclosing salary information. They can only do that to employees like Ms. Vivas, who have regular access to it, but by require them to get signatures from employees they want to disclose. There's no dispute here that EasyCater did not do that. They never did that. Ms. Vivas had regular access to salary information through her regular job duties. She had that information access through Google spreadsheets. It's on page 333, an example of this, of your appendix. On page 333, I have a copy right here. It's a Google spreadsheet that would she would, if she was asked to change, say, John Doe's salary information, she would get a link and be asked to get into this Google spreadsheet that would, so she could see John Doe's salary information, but the Google spreadsheet would also show multiple other employees' salary information. And she would look at John Doe's and change that salary, and she would be expected to just ignore the other ones. But the Google spreadsheet would show other employees' salary information. So on the day in question that caused this whole case, she was interested in seeing what if her raise had gone into effect, because she was told she was given a raise, but it hadn't gone into effect yet. So she did not have an assignment. We acknowledge this. But she went into this Google spreadsheet where she knew her name was. She saw her salary, and then she saw the salary of her male coworker that had a lower rank than her and saw that he had the same salary as her. Then she went and talked to that male coworker, told her about it, then talked to her supervisors, talked to them about it. She did not admit to them that what she had done, just said, oh, I talked to my coworker about it. Then they talked to her. Then the male coworker talked to the supervisors as well, and the male coworker said, well, I'm a little concerned. I heard because of how she found out this information.
Isn't that integral, though, that she lied about the source, and she knew that she was lying about the source?
Your Honor, she doesn't acknowledge now that she did. I wouldn't say she acknowledged now that she lied. She acknowledged that she did not disclose to the supervisors how she found out. So she didn't tell them the full truth. But
they said, how did you find out about this? And she said, we had a conversation.
So
that's a very creative assessment of what occurred.
I agree, Your Honor. I agree. But the plaintiff is not the one moving for summary judgment here. We're not the ones saying there's only one way the defendants the jury could find here. We're saying there's enough evidence that could allow the jury to find in favor of Ms. Vivas, based on Ms. Alla's own statements as to why did you fire her? And based on her own statements, she gave multiple reasons, one of which...
Yeah, but wait a minute. That doesn't really square, though, with the... I could see what you were saying if she were immediately discharged, but she was treated quite well. It's undisputed. She was treated quite well after the initial conversations with the manager and acting manager. So even if someone else in the organization somehow suggested to her that it was her mere conversation about the wages that was enough to get her discharged, following that conversation, things went well for her, and that there was discussion about, you're going places, we're going to get you further training, you're going to move up. They're all very positive. So that their conduct seems to cut against what the other, the personnel person had said about she discharged for her conversation. She wasn't.
Your Honor, first, I point out that that's what they said happened. She doesn't understand that's what happened. That was what they're saying after the fact, that we considered her promotions, that was never disclosed to them, but that is what they're saying. I agree that's admissible evidence. But a jury is entitled to consider all of the evidence. And as I said, Janina Allo was one of the persons consulted and was one of the decision makers. She says, I don't recall if I was one of the decision makers, but she was consulted. And she's the person who was asked by Ms. Vivas, well, tell me why I was terminated. So while what Your Honor says is correct, that the initial reaction when she was asked to discuss was, okay, I'll discuss this with you. When she was asked for an explanation as a reason for the termination, this is Rule 801D evidence, she was given an explanation that included the discussion. So that's admissible evidence as much as the facts beforehand are admissible evidence. We can't just exclude that because what happened beforehand is favorable to the defendant. We have to include all the evidence and let the jury make hay of what it is. You know, just because the first evidence is favorable to the EZCATER, and the second evidence is favorable is a favorable inference to the plaintiff, I don't believe we can just say, okay, well, the first evidence discounts the second one. When Ms. Allo is saying, well, one of the reasons is because of your discussion. That's what Ms. Allo is saying. Ms. Allo also testified in her deposition when I asked her, well, because they cited the policies. Well, what happens if an employee learns about some salary as part of a regular course of duties? Not because she snuck it and saw it outside of her course, but part of her regular course of duties, and then wants to talk about it. Then she says, that doesn't matter. She still can't talk about it. Well, that's directly contrary to MIPA, directly. So if we go for what a but-for test under what the Supreme Court says, and I didn't cite this case in my brief, but on the Bostock decision, which is from 2020, 590 U.S. at 656, a but-for test directs us to change one thing at a time and see if the outcome changes. Well, Ms. Allo did that for us in her deposition when she says, well, it doesn't matter if she saw this in her regular course of duty. She's still not allowed to talk about it. That's contrary to MIPA. MIPA says, no, yes, you are. If you see this in a regular course of duties, you're absolutely allowed to talk about this. Again, this is page 577 of her the appendix. So when she says our policies say you're not allowed to talk about it, the policy says, when she says...
She's not allowed to access it under the policy.
What?
She's not allowed to access it.
For the policies,
And did she do that?
She did do that, absolutely.
So that violates the policy.
Yes, but what Ms. Allo is saying is, you're on page 577 of the appendix, even if you access this because through regular course of duties, you can't talk about it. So she's saying it doesn't matter if the policies don't matter.
Well, if that's not true, but accessing it is a violation of the policy, why does it matter?
I'm sorry, Your Honor?
Why does it matter if that the policy doesn't prohibit her talking about it, but it does prohibit her accessing it? So there's the violation. What difference does it make if they're wrong about talking about it?
Well, Your Honor, the policy, I don't believe, does prohibit her from accessing it because the policy is not specific to IT personnel, and so she had regular access to it. And under the MIPA...
The ECF spreadsheet?
What?
To the ECF spreadsheet.
She had regular access to the Google spreadsheet through her regular course of duties. She had regular access to it. And under MIPA, if they want to restrict that access, she had regular access to that through her regular course of duties. She had regular access to the regular course of duties. That whenever she was asked to sort of update an employee's salary information, she would access the Google spreadsheet. And we acknowledge, there's no dispute, she was not asked to look at her salary on March 2nd, or whichever day in March she did this. So that, I acknowledge, she was not asked to do that. But it's my contention, as we say in our brief, that that is literally an inquiry, by definition of the word inquiry. The question should be, which I put forward in my brief, was it a good faith and a reasonable inquiry, as those terms are used in the civil rights context under 151B or anything, just as, is it a good faith and reasonable report of discrimination? If somebody goes into an HR and reports discrimination, is that done reasonably when they go in and talk calmly? Is that good faith and reasonably? Or is it done good faith and reasonably if they walk in and yell and throw coffee? Probably not. So this is how you have to...
But the statute doesn't talk of good faith, right?
No, but it doesn't do it in 151B either.
She's otherwise an at-will employee, right?
Yes, Your Honor. Your Honor, but I'm using the words good faith and reasonably as the courts have used it in the context of other civil rights statutes to define the breadth of what a protected activity is. The good faith and reasonably is the terms of arts that courts have used to define the breadth of protected activity under civil rights statutes, the whistleblower statute, the 151B statute, because we need to protect we need to ensure these civil rights statutes have protections without allow them to be abused. And that's what the good faith and reasonable language does, because an inquiry does not require a dialogue.
It doesn't
It
require
does not
what?
require a dialogue, by definition, by the word inquiry. I believe an employee is inquiring about wages if they look online as to a website that says, what is the average wage for my position? That's an inquiry.
All right, we're going to leave it there. Thank you.
Thank you, Your Honor.
Ms. Fergus.
Good morning, Your Honors. May it please the Court. I'm Kate Fergus, and with me is Patrick Parker. We both worked on the brief. I first want to start with something my brother said about Jeanine Allo's comments after Ms. Vivas was terminated. Her comment doesn't hint of multiple reasons for termination. It hints at two. Actually, it's directed to. If we read it again, she says, you accessed information that was confidential to review for your own information. You then used it in your conversations with your director and manager, misrepresenting the source of the information. There's two reasons she was terminated. One, you accessed confidential information using your privileged credentials against our policies. And number two, you misrepresented the source of that information during your conversations with your managers. Nothing else. The way my brother wants to construe this is nothing more than an exercise in syntax, and it is not enough to get to a jury. Moving forward from that, Your Honor, I really think
Well, what about that? I am curious about that. What if there is a subordinate, not the ultimate decision maker, subordinate who lets it slip that there is a protected reason for termination? Is that enough to get to a jury?
If the person was not the decision maker, I don't think that's enough to get to a jury, Your Honor, because it doesn't show that that comment infected the decision-making process.
What if the person consulted with the decision maker?
In this case, Your Honor, the undisputed evidence is the decision to terminate wasn't made until Mr. Andrews and Mr. Jones approached Ms. Vivas, gave her the benefit of the doubt, and said to her, give me a reason why you didn't do this. And she couldn't. She admitted what she'd done, and she was terminated on the spot. That's what happened. Nothing Ms. Allo said infected this decision-making process. They wanted to hear from her. They gave her the benefit. You mentioned that she was treated well. You're exactly right. She was treated better than well. Even in the face of all of the evidence that she logged in without a business purpose and, that she lied about it to her managers, they still gave her the benefit of the doubt. They didn't make that termination decision until they sat her down and John Jones said to her, please give me a reason why you did this, so I don't have to fire you. She admitted what she'd done, and they fired her on the spot. There's no evidence. Even if you wanted to construe, even if you wanted to take that exercise in syntax and construe Ms. Allo's statement that way, which I suggest there's no reason to, and it's certainly not enough to get to a jury, that did not affect the decision-making process in this case. The decision-making process was clear. You were terminated, Ms. Vivas, for two reasons. One, you used your privileged credentials to access information that contained the compensation information of everybody in the company, which you knew. You took that information, when you spoke to your managers about it, you lied about the source. I can't remember if it was you, Justice Allen, that said, it's clear she lied about the source, and she admits it. She admits both those things. Neither one of those is protected conduct. Jeanette Vivas' own words really tell us all we need to know in this case. She says, and I quote, if John had given me a heads up Friday of the conversation with NH complaining about me, I could have prepared and come up with a reason that would have kept me in that job. But they effed themselves. I didn't quote the F part, but the rest is her one regret is that she didn't have a heads up before that last conversation with her managers, so she could have made up another lie to protect her job.
Well, of course, all that, the employer was not aware of those statements, so that all came out in discovery, right?
That's true, Your Honor.
So that had nothing to do with the decision-making.
It did not have anything to do with decision-making, but it does help this court.
How so?
Because my brother mentioned that Ms. Allo's, in his brief, that Ms. Allo's comments are a window into the soul of EasyCater. I will tell you that all of those text messages are a window into the soul of Jeanette Vivas. You don't have to use them as a basis for termination, but they tell you a lot of things that are relevant in this case. Number one, she knew exactly what she was doing. She talked about it. She was worried she was going to lose her IT admin access if they found out what she was doing. Number two, she was freely willing to lie again in order to protect her job. And it also tells you that the fact that she doesn't remember why she accessed this information speaks volumes, because historically, she'd been accessing this information to gossip with her friends. And so my brother mentions reasonableness. No reasonable jury could find reasonableness in this case because she doesn't know why she did it. It would be backfilling the record and imputing information that she can't even tell us, Your Honor, because she was clear during her deposition she doesn't know why she did it. Ms. Vivas' attempt to use a pay equity statute as a get-out-of-jail-free card to turn her misconduct into protected conduct is frankly offensive to the spirit of the Act. To find her actions are protected conduct, this court would have to do a number of things. First, it would have to interpret the MUPA statute in a way that was not intended, expanding its scope beyond its plain language, which obviously was carefully selected by the legislature. It would have to impute a good faith motive to Ms. Vivas' actions in the face of her own inability to recall that motive, and in the face of a mountain of evidence that certainly suggests otherwise. It would have to ignore her shifting narratives for how she came upon the information. It would have to excuse her from EasyCater's reasonable security policies. It would have to extend vertigo beyond the limits imposed by the SJC. And it would have to open the proverbial door, permitting employees with privileged access to scour employee files and systems for confidential information, all under the guise of pay equity. Respectfully, Your Honors, these facts don't warrant that effort or result. Judge Cowan interpreted MUPA correctly. Ms. Vivas' case is an exercise in mental gymnastics, one which frankly turns MUPA on its head. Keep in mind, the MUPA statute is intended to promote pay equity by opening the dialogue between employees with each other and with their employers, so that employees can ask questions without fear of reprisal.
Let me ask you about that. Why wasn't it a violation of the statute when both the manager and the acting manager asked her, when she brought up the pay issue, they asked her something like, well, where'd you get that information, or how'd you learn that? Doesn't that come close to saying you shouldn't be discussing this?
Both of those individuals knew she had access to confidential information in a spreadsheet that contained the compensation information of everybody in the company. It's perfectly reasonable for them to make sure that she's not abusing her access privileges.
But it could be read differently, that why are you discussing this with your coworkers? You shouldn't be talking about this.
Well, when she said she discussed it with her coworker, they were satisfied with that response.
I'm sorry, they were what?
They were satisfied with that response. There's nothing in the record that says that after she assured them that it was through a conversation with her coworker, as opposed to violating EasyCater's policies, that they weren't satisfied with that response.
But you would agree there could be a potential violation of the statute if an employer gives pushback to an employee who's inquiring about differential wages, and the question is, well, where are you getting that from? Or why are you discussing this? Isn't that what the statute's designed to prevent?
The problem with your hypothetical is there's no adverse employment action. Getting pushback in a conversation from an employer, it may not be in the spirit of the MUPA statute, but there's no retaliation, there's no evidence of an adverse employment action that would trigger a retaliation claim under the statute. It's not ideal, I would agree with you, but it's not a violation of MUPA. Just going back to the MUPA statute and its interpretation, the legislature did not include the word access in the list of actions which could not be punished by an employer. The legislature was clear. Inquire about, discuss, or disclose wages under certain circumstances. That's the protected conduct. In fact, the legislature's only mention of the word access was when it described employers who allow access to certain employees, a statement which unmistakably presupposes that an employer can disallow access. Limiting access is exactly what EasyCater's acceptable use policy and its written information security policy do, policies on which Vivas was trained and to which she agreed. Both prohibit access to EasyCater systems without a business purpose. And the WISP goes a step further, preventing people like Jeanette Vivas, who have privileged access, from using that access without a business purpose. These are precisely the policies the legislature contemplated when it described employees who are allowed access under MIPA. Neither of these policies, which limit access, chills any rights under MIPA to inquire about, discuss, or disclose wages. Judge Cowan properly found that Ms. Vivas had not engaged in protected conduct under MIPA when she accessed her colleague's salary information in violation of its policies. This court, respectfully, would have to ignore the tenets of statutory construction to equate the word inquire with the word access, as Ms. Vivas suggests, making accessing compensation information protected conduct. By the way, I did look up the definition of inquiry using my brother's link, and the first definition of inquiry is actually to put a question or seek for information by questioning, which supports one of Your Honor's statements that it's more of it's a dialogue. It's not snooping and accessing confidential information. If an employer cannot limit access to wage information without violating MIPA, it essentially forces employers to disclose salary information, which MIPA expressly prohibits. It would also mean a custodian with a key fob to clean the building now has protection under MIPA to open the drawers of a file cabinet which might contain his wage information. According to Ms. Vivas, the only policy an employer can impose under MIPA is one stating that an employee who has access to compensation data can only disclose it with the consent of the affected party. She claims EasyCater's policies are invalid because they don't contain these terms. That construction ignores, as I previously said, MIPA's presumption that an employer can allow or disallow access, which is exactly what EasyCater's WISP and acceptable use policy do. I suspect her construction would be news to the legislature, and it would most certainly be news to employers across the Commonwealth, invalidating written information security policies, electronic systems policies, and NDAs of every employer in this Commonwealth. WISPs and electronic securities policies almost often limit use of an employer's systems to business purposes, and NDAs include personnel information and payroll information as confidential. Vivas' interpretation would render these policies unenforceable. Avoiding this distortion of MIPA proposed by Ms. Vivas, Judge Cowan interpreted MIPA's plain terms and held EasyCater's policies were not illegal under MIPA. Judge Cowan also determined there was no need for a mixed motive analysis here. EasyCater terminated Ms. Vivas for two clear reasons: using her privileged IT credentials and lying about it. And as Judge Cowan decided, there's no need for a mixed motive because neither of these bases are protected conduct under MIPA. The only protected conduct, which we freely concede, were her conversations with her managers. But Judge Cowan recognized in her decision, Jeanette Vivas did not produce evidence from which a reasonable jury could determine that her conversations with her managers were the reason she was terminated. In fact, as Your Honor pointed out, EasyCater's response to her protected conduct, those conversations, is precisely why no reasonable jury could find those were the basis of her termination. She wants you to think that Chris Andrews, when she was talking to him, that the tone of the room changed, that maybe we shouldn't be talking about that. But the undisputed facts show that Mr. Andrews sat down with her. He drew out salary bands to explain them to her, that she was satisfied with his explanation. It, quote unquote, made sense, App 112. Mr. Andrews then followed up the next day, providing her resources for women in technology, and everything seemed normal, in her own words. She also wants you to think that after she talked to her manager, Jonathan Jones, about her compensation, he used that conversation as a basis to terminate her. The facts show just the opposite, as Your Honor recognized. He told her she was going places, and he was researching leadership programs from her. And it wasn't until he received a complaint from her coworker that things changed. That's the superseding intervening cause in this case. That's why Mr. Jones had to investigate. That's why he went through all the steps to confirm what she'd done. And that's why he gave her one last chance in his conversation with her to say, this is why I did it, and she couldn't. She admitted what she had done. I do want to say something quick about the, I know my time is running out, but I do want to say something about Ms. Vivas's, quote, evidence of pretext. Her big statement about pretext and the evidence that is before this court is that somehow Mr. Jones's statement that every lie is a terminable offense is inconsistent with the 30B6 witness that said every lie is evaluated. I submit to this court that is exactly what.
There.
Oh, excuse me.
We're going to leave it there.
Oh, okay, thank you.
Thank you both. Our last case is 25P 655, Roman Levin versus Puritan Distribution Incorporated. Ms. Doherty.
Good afternoon, Your Honors, and may it please the Court. My name is Anastasia Doherty. I'm counsel for the plaintiff appellant in this matter, Mr. Levin. This case is about the independent contractor law. It's about the presumption of an employment relationship that law establishes where an individual provides services for a company for compensation. My client, it is undisputed in the record, performed IT support services for North Shore Shuttle. He's performed these services for 17 years for hourly compensation. Under the independent contractor law, which is the applicable law for determining his employment status for the purpose of wage and hour protections, he is presumed as a matter of law to be an employee of North Shore Shuttle. And this brings us to the crux of the appeal and the decisions we're challenging below. There is only one way for an employer to overcome the presumption of an employment relationship.
So can you go right to the heart of C, all right, and whether or not the gentleman was a worker in an independent trade, and speak to that, because I am having a lot of difficulty fitting him into being an employee where he held himself out as a contractor, lived overseas for a year without, well, it may be disputed whether or not the appellee knew, and so if you can speak to that.
Yes, Your Honor. So to begin with, the ABC test, conjunctive test, and I would direct the court to the Summers decision, the SJC decision by Justice Gantz, which makes clear, I'll just read from the decision, regardless of the agreement between the parties, to paraphrase, and regardless of the parties' intentions that the plaintiff's work be performed as an independent contractor, unless the defendant can successfully satisfy the requirements of the ABC test, the plaintiff is the defendant's employee. None of the statutory criteria speaks of the employer's intent, rather all speak of the nature of the services provided. So what we know from that decision is we don't look at the parties' subjective beliefs about whether they're an independent contractor or a consultant or the like. What we look at is the nature of the services that were actually performed. And what prong C asks, to go to Your Honor's question, is are those services being performed as part of an independent, established entrepreneurial endeavor of the worker? And we know this from the Boston Bicycle decision from the SJC. There, the court puts very plainly what the potential employer has the burden of establishing on prong C, because it is the employer's burden, once that presumption of employment is established, is that the plaintiff customarily engaged in his own IT support services on his own, that those services operated wholly independent of work for North Shore, and that it was established and running.
Wasn't he basically on call to provide services as needed?
I'm sorry, I'm not understanding Your Honor's question.
Was he, did he have an office at this company?
He worked remotely and he went into the office, but
So they called him in when they needed something to be done, right?
yes.
Did they give him a W-2?
Well, as we know from Summers, the labels don't control, right?
Can we answer the question, though?
No, they didn't give him a W-2.
Did he get a 1099 instead?
I presume so. I mean, in all independent contractor misclassification cases, the worker is going to have gotten a 1099. But what prong C asks is there an independently established business through which the worker is providing these services? So what the potential employer needs to show to meet its burden on prong C is that the worker was holding those same services of the type they provide to the company out as available to the general public, right? So you could adduce evidence that he actually provided these services to another company during that time. None was provided, that evidence.
Doesn't his letter to the employer show just that? Doesn't it to the appellee? Doesn't it show that he had his own independent business? He felt that was how he was holding himself out. He called himself, I need you to pay my business this. You understand because you have a business that I need to get paid for my business.
Right, so there's two reasonable inferences you could draw from him saying, holding himself out that way, which is one, maybe he did have other clients, or one, that he was posturing because he hadn't been paid in 4 months and he needed to get payment. And I would submit that the fact he didn't have other clients is actually undisputed in the record because he submits an affidavit.
Are there any facts in the record that he was posturing? Did he testify to that?
Yes, because at his affidavit at paragraph 20, he says, I never performed IT services for any other clients. And that fact is not actually.
Did he ever say that he was posturing, that he was puffing himself up as if he had a business to, I'm not sure what the posturing was, but does he ever say
I suppose I read that letter because it starts with, I've asked for this payment. You told me you were going to give it to me. You're not. I really need this payment. So right in that context, that is the reasonable inference I would draw. But I would say the material fact of the prong C analysis that Your Honor asked about is the fact that he did not have any other clients for whom he performed IT services. In fact, his performance of those IT services exists only through the relationship to North Shore. So it's not a case where he was advertising those services and came upon North Shore as a client. He began working as a driver for North Shore. And then he transitioned to providing those technology support services. And courts have found that to be a material fact when looking at the prong C analysis. We see that in the coverall decision, which also looks at prong C. It looks at the worker having begun providing these janitorial cleaning franchise services because she had already been servicing the account that led her to enter into that relationship.
But it seems like you're kind of reading something into C that I'm not seeing, because you seem to be suggesting that you have to have other customers in the trade or business, but C doesn't actually say that. It just says that you're customarily engaged in an independently established trade, occupation, profession, or business of the same nature. So if we were to read the statute the way you're reading it, then no one starting out could ever be considered an independent contractor if they only have one customer. If you start out, you have one customer, because of C, you can't be an independent contractor. You must be an employee. I mean, that wouldn't make too much sense, would it?
And that's a good point, Your Honor. So prong C is a totality of the circumstances analysis. That's Boston Bicycle. So other evidence that could be introduced to meet the employer's burden on prong C is whether provision of technology support services continued after his relationship with North Shore North Shore ended. There's no evidence of that. There could be evidence that he advertised those services, handed out business cards, posted something on his social media profiles or the like, and you see some discussion of that in the cases where there are all these different pieces of evidence that can be used to meet the burden on prong C. You're correct, we're not looking at one dispositive factor, did this person have other clients or not, and you also see that in this court's decision in Weiss, which is the recently issued appeals court decision, where this court found that IT worker at a finance company could be construed to be an employee under the ABC test. And I bring that up because in that case, I think it was actually a closer call on prong C than the case here because that worker had his own established business. He actually had an incorporated business, which my client doesn't have here. He had an agreement with North Shore as an individual who was paid as an individual on those checks. And the plaintiff in Weiss also did actually have other clients. He performed about 5 weeks of project work for an entity other than the potential employer. And the court, this court there found that still wasn't sufficient for the employer to meet its burden on prong C. So on prong C, you are looking at the totality of the circumstances. It doesn't rise or fall on one factor. If I may briefly return to a couple of points. First, and we have gone over this, ABC is a conjunctive test, and I would like to make clear that what that means where there are cross motions for summary judgment on employee status, as there were here, is that for the plaintiff to prevail on the question of employee status at summary judgment, he need only show North Shore will be incapable of proving one of the prongs. That is the only showing required for judgment as to employee status to enter in his favor. Conversely, for the defendant employer to prevail on summary judgment, it needs to show that it can prove every prong. And there's no reasonable expectation in the record that even one of those prongs is subject to dispute. And I think that is very important in reviewing the record here, understanding it is a strict test. It is not the common law test for control, which the legislature has eschewed and rejected as the applicable test for wage and hour protections in this state. And I point that out because I do think some of the analysis below tried to short-circuit the ABC test by relying on the plaintiff's self-description, and Summers directs us to look at the actual duties performed. Speaking to that briefly, I encourage the court to look at the actual duties that my client performed for North Shore. We've described them in the brief as in-house IT support. If you look at the granular examples, what he did was, for example, when North Shore used Webtilia to work on its website, he acted as an intermediary and liaison. He did quality assurance on the website, looking at emails that were spelled incorrectly, links that did not work, asking for colors to be changed. There's other evidence in the record of his support tasks, including helping combine multiple files into a single PDF, attaching a large PDF to an email, calling GoDaddy about email prices, replacing and updating phone software. So what the record shows is that he performed an array of support services, and he performed these on an open-ended basis for 17 years. That's much longer than the plaintiff in Weiss, who was working for the potential employer for 3 years, where the court found it to be material and persuasive that it was an open-ended engagement. And I emphasize that point also to draw a contrast between the work my client did here and that of a true contractor. For example, a freelance website developer who is only coming in to help with the design of the website, build the website, and may have other clients or be searching for other clients. I'll just briefly direct the court back to Weiss to submit that North Shore will be incapable of meeting its burden on prong B because in its particular business, like the business in Weiss, the technology that my client supported was integral to running the business, where it was doing booking reservations and dispatching. Lastly, on prong C, which I do believe we have addressed in this argument, I would point the court to Coverall North America, which is cited in our brief, which explicitly rejects what it terms the capability test, which is the argument that simply because he could have provided IT support services to someone else does not mean that the prong C burden is met by North Shore. If the court has no further questions.
Seeing none, thank you. We'll take it under advisement.
Thank
That'll
you.
conclude our session. I want to thank our court officers. I want to thank my panel, our law clerks, our clerk's office, and our excellent timekeeper, and we will stand in recess.
All rise.